For your information, when somebody talks, they tend to show up in the top right-hand corner of my screen. And that's the person I'm normally talking to. But I headlined this a new series of classes because it is sort of lead into the Constitution of the United States. And I think you've all seen at least a tentative list or a short list of the classes I'm going to cover. The one I used last week was sort of a standalone that dealt with democracy from a variety of viewpoints and was something that I was going to use, well, probably 10 years ago as a start for a different kinds of set of classes. But this one will lead us into the Constitution, sorry. Okay, so I thought the perfect starting place would be the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. I think some of us had to learn this in school. I was not one of those, but it is certainly a statement of what the Constitution was about, or was to be about. And
Bill,
at some point, yeah.
I'm curious as to why you're starting here rather than the Declaration of the Declaration of Independence, which
Well, I'm starting way before the Declaration of Independence. I just felt that the first part of the first statement would be the preamble. But I'm going to take you all the way back into English law through today's discussion.
I'll shut up for a little while then.
Oh yeah, this hour and a half will be dedicated to pre-Articles of Confederation information, which is where I plan to go next week. So this is what I'm trying to deal with as we go through this series of classes. Initially, when I first put it together years ago, there were people that were concerned about what the country was like and how it had sort of moved away from negotiation and compromise. And one of the things that seems to turn up is that a lot of people don't remember or don't know the details of what the Constitution really says. Just as an aside, I'm reading a book right now that deals with both the pro and anti-slavery views of the Constitution that were rampant in the middle of the 19th century. But the document itself, once we get to it, is really complex, and it's been interpreted a variety of ways, and the interpretations change during periods of time as peoples change, as immigration changed, as the Civil War came and changed the country. And so there are various ways of deciding what they mean, and that's what the Supreme Court is all about. And one of the reasons, towards the end of this series of classes, I will discuss at least the earliest days of the Supreme Court and possibly go into John Marshall's interpretation of it. But what my goal is to hopefully weave our way through what the Constitution is, where it came from, why it was important, how it was put together, and the other segments that I've got specified here. The Articles of Confederation, creating the Constitution itself, the ratification, the Bill of Rights. And those are the things that are key to the document itself. But then there's the Electoral College, talking about chief justices. I can't decide whether I'm going to go into Washington, D.C., the creation of it, because it does have political aspects to it. And then talk about Jeffersonian and Jacksonian democracy to show how the concepts built into the Constitution were sort of modified or subjectified once we moved into actualities. So let's see if there's anything important about that. But some of the things that will be discussed are the content of the people or the people that were involved at various times, particularly Hamilton had left off, well, Jefferson certainly, and I left off Madison. He should be in there. Andrew Jackson, potentially just as side comments, the Roosevelts and some other presidents. But my intention is to try to stay within the confines up to about the end of the Civil War, maybe a little bit further. So these are the things that I'm probably going to do. I'm repeating myself, so I apologize. Reconstruction might be a separate discussion as well. I never did get to this section, so we won't go there. The idea here is to present things clearly enough so you don't have to remember where we left off. I've hoped to break these down into individual discussions, and this one is a little bit obviously intended for introductory points. So I put this down for people that had originally signed up. Years ago, when I put these things together, everybody paid for everything. And this is the one class I give now that people have to pay for. But once I get started, you're sort of hooked, I think. So I've given people the chance to opt out. Okay, I wanted to go through some general stuff before going backwards in time. Obviously, the Constitution represents the supreme law of the United States. And the two key words in there, or phrase and words, are the supreme, being this is the ultimate statement of what the laws of the United States should be. And the United States, which in a sense changed in definition from pre-Civil War to post-Civil War. Pre-Civil War, when you were talking, if somebody spoke about the United States, they would say those United States. The idea that these were separate entities. After the Civil War, they became the United States, because at that point, the concept of secession was basically eliminated. There are 7 articles within the Constitution. The first 3 talk about the separation of powers, the executive branch, legislative, judicial, and I'll go into more of this detail certainly as we go through. But judicial became the one that was most hotly argued about and discussed, because there were people such as Jefferson that didn't feel as if there was a need for a separate judicial equal branch of government. And it really took until John Marshall became Chief Justice that it did become a true part of the triad. Articles 4, 5, and 6 deal with federalism, the rights of the state government versus the rights of the federal government, and how the state government relate to the federal government. And this too became interesting in terms of definitions and interpretations, and is again part of this book I'm reading right now. And Article 7 establishes a procedure that was used by the 13 states to approve it. Also, it turns out that it wasn't necessary for 13 states to approve it. Yes, I'm sure.
Pick somebody to talk.
Okay, go ahead, Jeff.
The Constitution represents the supreme law of the United States. How does that relate to treaties that have been ratified by Congress, which are with other countries?
That's one of the specifics that's built into the Constitution. It's the federal government's ability to enter into foreign relationships, and the states not having that right.
Right, but the question is, when you have a treaty with another country, does that supersede the Constitution, or is it subject to the Constitution?
Subject to. Okay. Okay. So let's see. I keep thinking I'm getting to where I want to go, but I'm going to keep plodding through this way. Constitution became effective March 4th, 1789, and the 3 branches of government were created. And it's kind of interesting to try to put yourself in the position of the founding fathers and the people responsible for these branches of government, because you're really starting from scratch. There are a whole range of forms of precedent one could look at, but they had never been put together in one entity before. It has been amended 27 times since first created, and most of the amendments dealt with changing society. Some dealt with some questions related to the Constitutional Convention, and things that should or should not have been included. And when we get to the discussion of the Bill of Rights, you'll, I think, get an idea of what the differences were and how they were dealt with from the period of time of the initiation of the creation of the Constitution till the ratification. And the 18th century is certainly substantially different than the 21st. The Bill of Rights, I'm not going to go into at this point. Most of the other 17 amendments deal with expanded civil rights protection, but you also have things like the introduction of elimination of alcohol and then the end of it. So you get a couple like that. And there are the amendments are appended to the end of the document rather than the document being rewritten and being recreated, if you will. And the first 4 pages of the original are written on parchment. And for those of you who've been to the archives, you've seen it. This is a quote from the Senate of the United States. Constitution's first 3 words: "We the people affirm that the government of the United States exists to serve its citizens." For over 2 centuries, the Constitution had remained in force because its framers wisely separated and balanced governmental powers to safeguard the interests of the majority rule and minority rights of liberty and equality, and of the federal and state governments. Now, this one of the comments to think about, and I really don't want to go into it now because eventually I'll get to that as well. But the idea of majority rule and minority rights, that's really one of the things that's been under discussion in the questions about eliminating the filibuster. The idea of the filibuster was exactly that. There is a majority rule. In today's case, the Democrats control the executive and legislative branch by narrow margins. But by keeping the filibuster in place, that's intended to protect the minority rights, those people that might be superseded. This is what the first page of the original looks like. Again, it's in the archives. And now I'm going to start going backwards. The English law has to be looked at as really where the Constitution came from. And English law, English government is not based on one single document as is the United States, but English law preceding the creation of the United States and even the creation of the colonies comprises both civil and criminal activities, criminal legalities. And there is no formal legal code. If you were to go into English library and look for a book that covers all of English law, you probably wouldn't find one. And you wouldn't find a constitution of any sort. And you'd have to go back through a lot of documents to come to the point that we, the colonies of the United States, use them. So it's really, the laws themselves have come from a variety of different judges in a variety of different places throughout England, where they applied statute and legal precedent from previous cases, much as law is done today. If a judge is to make a decision and lawyers are to present arguments, they usually have precedents in the past that have been approved or disproved and use them or negate them as they move forward. Some of the rulings are based on things that are done through legislation. Others that are called common law are these precedents. And this is some of the examples. Murder is a common crime law rather than one established by the House of Commons. So common law that pre-existed before the House of Commons was such that murder is a crime. And the definitions of murder may vary from place to place or type to type. But even if it's a common law crime, it potentially can be modified by Parliament. So murder now comes with a mandatory life sentence instead of the death penalty. So the House of Parliament has the ability to change things. And that in itself is the movement of English civil law from where it may have been, or criminal law, from where it may have been in the 15th or 14th century to where it is today. Really seems to start around 1189. And if you think of 1066 as the real changing point in English history, It basically takes a century for the new government of England, the new Norman governments, if you will, to start getting more solidified. And since that period of time, it's been described as common law rather than civil law. And that's because of this fact that nobody's ever really sat down and written a whole series of codes that saying this is established for the entire country. And judicial precedents are are considered binding. That if a judge says that, what's a good example? Shooting owls is illegal, and you're in a place where owls are a pest, unless there's some overriding of that rule, that's binding. Even if those owls are a pest, you can't do anything about it. And it certainly is a legacy of the Norman conquest. If you go prior to the Norman conquest, even though there was a pseudo or semi-unified England, it was not really one homogeneous entity. And that's part of the reason that the Norman conquest worked, because there had been another war almost immediately before the Normans arrived that basically put the English in a dire strait. And a lot of the things that came from Normandy came from that French section, became part of English law, if you will. So you wind up with this kind of interesting combination of some, call them precedents that had been established prior to the arrival of the Normans, or attitudes. And then with the Normans, they brought some of their laws along with them as well. So you really have 1189, 12th century towards the end, as we're sort of the first step in moving towards the United States Constitution takes place. So talking about Norman law, it itself started about the 10th century and was still being redeveloped, if you will, over the next 3 centuries, as it happens with most areas, most countries. And if any of you have gone to the islands of Jersey or the other Channel Islands, the laws there are very specific to Norman law. In a way, it's looking at Napoleonic code still being used in Louisiana in some places. And Norman law was really kind of interesting. And this is a true historical potpourri of things. But there were Frankish customs that existed in what we call the landmass of France, excuse me. And then the influx of the Normans, or the Vikings, if you prefer, that came both to England and to mainland Europe. They had their own set of rules and regulations. So Norman law becomes an agglomeration of those. English law became an agglomeration of Norse law plus English law. And you have this melding of 2 variants of a theme coming together in one place. There were traces of Scandinavian law that still existed, and specific word that was used. It was derived definitely from an Old Norse word. And it's a charter that had several pleas before a duke, referring to the punishment of banishment. So you wind up with these interesting anachronisms built into documentation that's carried forth from the 10th century into the 14th century. One of the things that existed, even though there was a kingship that was responsible for the country was broken down into groups as it is today, or segments as it is today. And in the early centuries after the Norman takeover, justices and judges, which were basically synonyms, they were responsible for taking these concepts, legal concepts, and adapting them to their locale to meet whatever people required. So if you're in a section of England where the most prominent business would be some level of mining versus another section of England where the primary business would be shepherdry, you would have the ability to adapt the overall law to those specific circumstances. Over time, as the government changed and started to look at parliamentary involvement with the royalty, as it became more established, then legislation became more important. and gradually over time became sort of the ruling decision-making process. So you wind up with this kind of interesting thing that I think fits in with pretty much any growth of law within any country, a mixture of precedent. This is what had been done before, and common sense, even though we sometimes seem to lose track of common sense, is usually built into the kinds of decisions that are made, that they're not just arbitrary, and they have to deal with the people, the population for which the justices or judges are working. So one of the examples I used was the idea of a law merchant derived from the PA powder courts, which were the implication of ad hoc marketplace courts. So the idea was, if they're in the old days, you didn't have judges that were running around on a circuit. You would have a person within a township, say, that was the judge or the justice. And when will you get most of the people together? Well, there were markets that would occur weekly, monthly, quarterly, depending on the location. And that would be the time and the place when these justices would be able to hear various complaints from various people. And these would primarily be dealing with land problems, ownership problems, those kinds of things, which generations or centuries later would have been held by circuit courts, where one judge or group of judges went from place to place. There's a thing called the Books of Authority, or a term called the Books of Authority, and they go back to this period of time, somewhere between the 11th, 12th, 15th centuries, where there were some legal textbooks that were being put together, where the decisions made in certain locations were being compiled and would be used, primarily compiled by, call it shire or district or region. And they would be put together with the idea of being used by the next generation. And what they became was sort of authoritative statements of what should be. So they were written on the authority of the authors themselves. Oh, I'm Judge X that lived in Essex, or ruled some portion of Essex in terms of judgments. And everything I wrote down was either written down by me or a scribe. And they became a book of authority that would then be used by whoever took my position further on. And they would be used from generation to generation. And those that still were applicable were still being used probably today. And those that became anachronistic because of changes in society, they were just either left on the books and never used, or left on the books where people that are looking for really odd precedents can go find it. And they are cited and relied on in court now. When we get it to the point where we talk about decisions made in the Marshall Court, a lot of it, and even subsequent to the Marshall Court, you will find things in there that actually link back to early English law, and people are still using them. And I assume most people have heard of Blackstone's books. Blackstone sort of codified his version of what the law should be. And he wrote this concerning the books of authority. Besides these reported, there are also other authors to whom great veneration and respect is paid by the students of the common law. Such are Glanville, Bracton, Britton, Fleda, Hingham, Littleton, Statham, Brooke, Fitzherbert, and Stotterford, and some others of ancient date, whose treatises are cited as authority and are evidence that cases have formerly happened in which such and such points were determined and which are now settled in first principles. One of the last of these methodical writers in point of time, whose works are of intrinsic authority in the courts of justice and do not depend on the strength of the quotations from older authors, is the same learned judge we have just mentioned, Sir Edward Coke. So if you look at this in general, there are what's that, about 10 different names that are specified as older decision makers. And then he says some of ancient date, meaning even older than that. And these are authority. from which any decisions should be made. But it's not an process that's ended. It's a process that's continuing, by mentioning Sir Edward Coke. So it's something that is moving forward. In each case, as these recognized experts put their things down in their book of authority, it becomes this collection of background and precedent that others should use. Just to break the monotony of my voice, this is what Sir William Blackstone looked like when he was dressed to be in court. So we now move, I mean, this is a picture and the statement is a picture that's beyond the period of time I've been in. But since he's a name that people know, a little bit about him, he lived from 1723 to 1780. The book that he's noted for is called the Commentaries on the Laws of England. So it's not as if he took everything together, but he took his view of what the books of authority should be, how they should be used, proper authors that should be considered, what the various laws in various locations are like, and how they should be considered. He was a barrister, eventually became a university administrator, and was known for helping the university, Pembroke College, become a little bit more efficient as a way. In 1753, he gives up his practice, starts lecturing around and speaking on English law. So it really takes from about the 12th century till the middle of the 18th century for someone to speak generally about English law, telling everybody that might have an interest of what they should and should not know. He made a lot of money by doing this, and it led to another book called The Analysis of the Laws of England, which was used as a preface to other works later on. So he made commentaries on it, and then he tells people after the fact his view of which laws should be canonized versus which ones might be modified, those kinds of things that he put together in the analysis. And the Analysis of the Laws of England is the one book that probably had transferred itself more than any other into the becoming United States. He became a professor of English law at, let's see, I don't have the, oh, there it is, Oxford, sorry. Again, getting a decent amount of money. And he did a lot of lecturing on the study of law. In a sense, he becomes the first truly law professor in a period of time where most other lawyers had been gotten their job through apprenticeship and eventually working in the courts. He became a lawyer again, published the first commentary in 1766, but as you can see, it was reprinted a number of times and made a lot of money in his time as well as today's time. So he's an important figure in looking at English law as codified, as brought to the United States, as analyzed. So the information that came from early England and progressed through his time would have been in the hands of pretty much everybody of importance in the early founding fathers, when you think of how many of them were lawyers by profession and lawyers by interest. Originally, the commentaries were intended for practical use and were published until the 1870s. There was another working version reprinted in 1841 and kept being printed until after World War II. So it's not as if Blackstone's influence died in 1753. He still has impact, or had impact, in England until the end of the Second World War. The Blackstone's work gave the law at least a veneer of scholarly respectability. And that's kind of an important statement, because the presumption would be that before he went through this analysis and his commentaries, it was sort of a hit and miss kind of thing. If you learn your law career through apprenticeship in a law office, then you're subject to how good or poor the teacher is. And by having, in a sense, legal education that's university oriented. It's no longer a veneer potentially, it's real scholarly respectability. One of Blackstone's successors said, if the commentaries had not been written when they were written, I think it was very doubtful that the United States and other English-speaking countries would have so universally adopted the common law, which also puts it in an interesting case. If this had not been done, if Blackstone's commentaries had not come to the United States, had not been read by Alexander Hamilton, John Marshall, James Wilson, John Kay, John Adams, James Kent, Abraham Lincoln, what would they have done in terms of coming up with the creation of the United States? What would they have looked at? Would there be any kind of background information they could use? They could look at the British Houses of Parliament at that point, but they're rebelling against that. So maybe they're looking at something else. But to create something out of whole cloth versus something that has had some logical background to it and then using it makes more sense. And as I've said before, if you look at Supreme Court decisions, lots of them will go back to things that came from Blackstone, which in turn came from something preceding that. The common law came to most parts of the United States. If you think of the creation of the United States, virtually everything came from England. There were certainly Germanic influences at some point. There were Protestant and Roman Catholic influences in certain places. But a lot of what was built into the English common law stayed within US common law, US criminal and civil law, even after the country was separated from the mother country. And because the Supreme Court is still using that today, there certainly has English law as a basis for our traditions. There are certain practices that were specifically outlawed in the Constitution, however. In looking at the variety of things that were considered valid in England, when the Founding Fathers decided to put things together, they decided to eliminate bills of attainder. And that was legislature that declared a person or group guilty of a crime without a trial. So this gave the king potentially, or if you transfer it to the United States, a president potentially, the ability to basically say somebody's guilty of something without a trial.
Hello.
I'm not sure who that is. Also, the idea of general search warrants. This country does not allow general search warrants. They allow search warrants for specific things, specific locations, and not this broad brush thing where you can basically cover everything without having specific search warrants. And American judges have the ability to make the law. A judge can make a decision based on his interpretation of things that have gone on before. He can look at the precedents that he's relying on and decide that they do not cover this specific event. And they can then say, this is the law, this is my decision. And that becomes a law in effect, unless it's of course repealed. But this becomes a precedent for future cases. And that does not happen in English courts. Judges do not make laws. Back to the US. The first governing document in the colonies was the Mayflower Compact. That's when the first organized group of people, I guess I'll call it, come to the United States, got blown off course, weren't able to make it to Virginia, came up into the Plymouth colony, and the decision was to cover the governing of this group of people. It was written by the male passengers of the Mayflower. Women had no vote in the matter. And there were two groups of people on the ship, which I don't think is generally known. One of them is the ones we think about, the separatist Congregationalists, the Puritans, the ones that had come that were fleeing from religious persecution. James of England was not in favor of the Puritanism of their style of Christianity, and they called themselves saints. There was another group of people on the ship that were the ones that were looking at this as some place to set up businesses, to find new ways of exploring, to potentially find new ways of making an income. So you had the strangers and the saints both together. And if you're trying to create a set of laws that cover both types of people, it tends to suggest that you become somewhat more lay-oriented rather than religious-oriented in trying to put together these other requirements. Over the last couple of weeks in another class, I've been talking about communal ideas that came from Proudhon that led into a variety of variations of socialism and of anarchism. But in a sense, the Plymouth colony can be looked at as a communal kind of environment where everybody would be having, would have a certain task and a certain responsibility. They would be required potentially to work together if they were attacked by indigenous peoples, or maybe certain people were asked to do certain physical jobs. It was signed on the ship on November 11, 1620, based on the old style dates, the Julian calendar, which was behind the Gregorian calendar. There were 41 of the 101 passengers on ship that signed the thing. And the specific location was the northern tip of Cape Cod. So you've got this interesting document. I do have another thing somewhere that's much more detailed on this. But again, here's an interesting painting done by Jean-Léon Jérôme Ferris in 1899, but gives the idea of the people that were signing it and the obligatory pilgrim kind of hat on their head, and the adventurer, the Spanish conquistador kind of helmet that they're wearing. As I said, the Mayflower was originally on its way to the colony of Virginia. It was financed by the Company of Merchant Adventurers, and it wound up because it got blown off course, and it just decided to stay there because they were running out of food and supplies, didn't know how long it would take them to get back down to Virginia. And they thought, well, we're here. Maybe we're better off here. Why should we go down to Virginia? Because here they would use their own liberty, for none had the power to command them. Here they are, they're in their own place. They don't have to report to anybody. There would have been potentially a governor already in Virginia. And you have this interesting ability to create your own set of laws. You're thousands of miles away from England. And you don't know how long it's going to take for new people to show up. And you might as well set up your own structure. And how do you do that other than creating your own set of laws? So they were trying to prevent a form of anarchy, which would have happened if somebody didn't basically say, let's structure, let's organize. The Mayflower Compact, based on a majoritarian model and the settlers' allegiance to the king. Now, they still were British citizens, so they had some awareness of, knowledge of what Parliament was like and the kinds of laws that had been important. Basically, it's a social contract. Everybody says, okay, these are the rules and regulations we're willing to follow in order to have things orderly, in order to survive. We're in this god-awful land. We don't know what's going to happen here. We really don't know what people are here, and we have to be able to survive. Most of them probably knew that the original settlement in Virginia, people had disappeared, and nobody knows to this date exactly what happened to them. They had lived in the Dutch Republic and the city of Leiden for some years. So they would have had some idea of how the Dutch Republic operated in terms of things that were legal versus illegal, and would have had some smattering of information about that. So the Mayflower Compact would be looked at as sort of a combination of those things they had gathered or gleaned from both locations. And one of the quotes on this is, just as a spiritual covenant had marked the beginning of their congregation in Leiden, a civil covenant would provide the basis for secular government in America. And the difference between spiritual and civil is very important, because it would have been difficult for the so-called strangers to agree to a spiritual covenant where religion was the key point. Now, as history turns out, religion became increasingly important in causing some of the inhabitants to move off. But that in itself is also a separate subject. The governor of the new state or New Plymouth area was William Bradford, and his transcription of the Mayflower Compact is the one that's most well known. And it's, if I remember correctly, it's been printed 3 different times, or he rewrote it 3 different times. And there are minor variations between the two. But unfortunately, I can't enlarge this image, so you can't read it, I don't think. But it does indicate what the rules and regulations are that they've agreed to. No, I do have some, and there are 3 versions. First one was printed in a place called Mort's Relation, 1622. And Mort's Relation was this first-hand attitude of what had gone on in the colony. And it was reprinted in another book in 1625. And this is where Bradford himself wrote down the history, the first 4 years of what life was like in the Plymouth colony. And that was the one that was most authoritative, had the most detail and information. And Bradford had also written another version of it in his thing called the Plymouth Plantation in 1646. I've mentioned this in other times, but it's just worth repeating. Until somewhere in the 18th century, latter part of the 17th century, spelling, capitalization, punctuation was kind of arbitrary. People spelled things different ways, and it didn't make much difference as long as you could understand it. Bradford wrote the first part of Mort's Relation, including the version of the compact, and therefore he wrote 2 of the 3 copies that are around. His handwritten copy, which would have been really nice to see, is in the State Library of Massachusetts, not in the Federal Archives, not in the National Archives. So some of the things that it specifically said, we whose names are underwritten, loyal subjects of our dread sovereign King Lord James, by the grace of God of Great Britain, France, and Ireland, King, defender of the faith, etc. And it was, etc. And having undertaken for the glory of God and advancements of the Christian faith, the honor of our king and country, do by these present solemnly and mutually in the presence of God and one another, covenant and combine ourselves together into a civil body politic for our better ordering and preservation and furtherance of the things aforesaid. So the key points are sort of combined in this ending, where the idea of a civil body politic for better ordering, preservation, and furtherance, that these things are intended for us to be able to not only survive, but thrive and keep ourselves working together in as harmonious a way as possible. Let's see, the actual list of the 41 male passengers wasn't supplied until years after the event. The original was lost, so nobody has a copy of the first compact that was actually signed by these 41 people. So it took his nephew to tell who the names were. Thomas Prince first numbered the names in a chronological history of New England, and he just put them in some order because he couldn't have known the actual order that they were had signed it. Just one of these little miscellany. But people that's names we probably know. John Carver was the author, first signer, first governor. William Bradford, who became the most well-known of the early governors. Miles Standish, John Alden, if nothing else from the poem. William Brewster is a name that's relatively familiar, I think, but he was the sort of the leader of the religious portion of the community. He was the one that was responsible for keeping them religiously together. And there's a man named Edward Winslow that was the colony's agent in London. So he would have been the one that signed the document for sure, and then went back to London prior to anybody else, and bringing the good news that they had landed, not in Virginia, but in another place, and were now moving or organizing there. Paralleling in terms of bringing law to the United States. The Virginia colony was under the control of the governor's council, was like the upper house of a colonial legislation, also called Council of State, or just the council. It was, in a sense, not quite a complete replication, but a variation of what was going on in England. It existed for over 170 years, almost 170 years, and was the upper house of the colonial legislature. So it would have been like the House of Lords in England, and the House of Burgesses was the lower house. The country, or the colony as it was established, sort of said, okay, we'll have a governor, and that governor will be the king's representative directly. The primary landowners, the wealthiest of the group, will create this Council of State, the ones that will advise the governor most accurately or properly related to the ownership of things. And then other landowners would represent the lower house and was represent, in a sense, of parallel to the House of Commons. And the Governor's Council was 12 men that had been appointed by the British sovereign. So he would know who was in the colony, or as new people were coming over, may have included them in, eliminated some other people. But it was this relatively small group of people. I guess you can think of it as the parallel to the cabinet of the United States that would be working closely with the governor. It also was advising the Virginia royal governor, and it was also the highest judicial body in the colony. So the law in the colony of Virginia would have been under the control of this council. They would be the ones to determine what the laws were, and they would have been the ones that would have carried with them whatever books of authority made the most sense to bring along. And the probability is books of authority would have been on the Mayflower as well, but maybe not. But they definitely would have been eventually brought into Virginia, certainly by the time you get to around 1630s. Originally, Virginia was under a charter granted by King James I, to a thing called the Virginia Company. And each of these new locations were set up as companies where some people in England had gathered together with the idea of funding this exploration, with obviously the goal of getting money back, making money on this investment. It had a governing board in London, and they appointed a group of 7 people to manage the day-to-day affairs of the colony. These would have been probably the second sons that were sent away, get a good new position. You'll have first dibs at whatever land is available, and you'll be responsible for getting this colony structured properly. The first president of the council was this man, Edward Maria Wingfield, and he would later choose the site for where Jamestown was set up. So he is an important minor name in history. But you have Virginia having a group of people assigned by the company to go deal with this new country. And this is the kind of attitude the British took all the way through the mid-19th century, where things like the East India Company would go establish a foothold in India. And then eventually, depending on circumstances, the government would take over. In early days, there was a lack of good leadership in the council. It sort of suggests that the 7 people that went had serious differences and couldn't get along real well. And they landed at Jamestown in 1607. And there was this really series of problems where internal dissension, allegations of lying, some of the counselors died. Instead of being 7 people, it was smaller and smaller until you get to 1609. Winter should be winter of 1608-09. Only 1 person was left. So in a sense, you wound up with the Virginia Company having only 1 representative left. And Virginia Company found out about it and decided, forget about it. We won't have any kind of collaborative government. We will control it from England through 1 person. And this took until 1918 before a new governor had come into position. And the king by then had issued a 3rd royal charter. So you have the original landing at Jamestown, that where everybody disappears. You have this 2nd landing in Jamestown, where things are uncomfortable, to say the least. And then finally, in 1618, things seem to have settled down after the king reissues a charter for the 3rd time. Here, they decided they would try to set up something parallel again. And they were looking at both a representative and consultative form of government. And it was built this way. There was a governor that was established by the Virginia Company. Since it's a private venture, if you will, they could determine who they felt should be responsible. In real world terms, they certainly couldn't put somebody in the position that was offensive to the king or offensive to the houses, or certainly the House of Lords. There would be a council of state that members were chosen by the Virginia Company. So they, in a sense, were changing the title a little bit, but the goal was to get this group of people together that could be trusted to work together and support the governor, help him as much as possible. And this group was charged with helping him, the governor, execute his duties. The first of these was the advancement of the honor and service of God and the enlargement of his kingdom amongst the heathen people. So this is one of their mandates. They're supposed to enlarge the kingdom of England. So here's Virginia. They're in Jamestown, and their goal is to go out and multiply, in a sense, the population, in a sense, the amount of land you have under control, and control those heathen people, the Native Americans that live there. And it doesn't say how to treat them. And that becomes part of what the Council of State becomes responsible for. And much as in Plymouth, where the logical thing is to have peaceful relationships with the locals as much as possible, because you don't want to be in a fighting situation. And you have to sort of expect that the indigenous peoples know how to find things, where water sources are, etc. They work with them. There was another branch of government that was built into this 3rd charter revision of Virginia, and it was the council, again, and a House of Burgesses. So the form that the 3rd charter took really wasn't that different in terms of having an upper house and a lower house and a governor. But the house included 2 burgesses from every town, hundred, and particular plantation, chosen by the free inhabitants thereof. And the word free is an insert, obviously, because by the time you get to the 1630s, there are some indications or implementations of slavery, certainly not what was to come. But the word burgess originally meant a freeman of a borough. And here, 2 burgesses from every town, hundred, and particular plantation. So the hundred is the interesting one to me, because every town makes sense. Got a town of Jamestown, if there are whatever number of people, but there are 2 people selected as burgesses. Particular plantation, the assumption being that there's a big landowner. And so they wind up doing what was done in Parliament, sort of loading it in the terms of having the wealthier people represented on the House, in the House of Burgesses. But the 100 suggests that there are a lot of smaller farmers potentially as well. And that from a group of 100 farms of whatever number of acres, but small enough not to be considered a plantation, they too would have some representation. So it does suggest that the House of Burgesses in Virginia was a little bit more democratic than the House of Commons would have been in that century in England itself. As the word was used over time, it became translated to mean an elected official of a municipality or even an unelected one, but somebody that had a specific job within the city or representative of a particular area, which sort of fits into the town and the 100. And by doing this, the governor's power becomes reduced because the House of Burgesses and the council potentially could have the wherewithal to either control which way the laws went or control the governor himself. And part of it is how strong the governor was. Prior to this implementation of the third charter, the governor was pretty much the king in place. Whatever he said had the same kind of cachet as what the king would have said. There's a charter that comes out of this. And in this new charter, it was decided that council decisions would be made by a majority vote. So very simple, plain democracy within a small group of people. And the governor was only able to cast the deciding vote in case of a tie. So as you can see, there are certain implementations of something in the 17th century in this limited territory or colony of Virginia that has some echoes in the 21st century, where you have in the Senate the ability to have the Vice President of the United States cast a deciding vote in case of a tie. So this concept is one that has progressed for the last 400 years. The General Assembly and executive legislature hybrid was to be the voice of the colonists in Virginia. So the House of Burgesses and the fact that there is an executive as well as legislative. And the use of the hybrid was kind of interesting because I did this quite a few years ago. But the General Assembly was elected by the people. But the people were landowners. They weren't everybody. You had to have a certain amount of land, or if you were in a town, a certain amount of assets. And it wasn't universal suffrage is the way to look at it. It was somewhat based on the British system, which most logical. How else would you do it? It would be, again, hard to create something out of whole cloth. And by having these houses and the council, it was intended to put a check on the governor, to rein in the king's power. And this proceeds from 1630 on and on and on. And the same things were starting to happen in England, but at potentially a slower pace, because over time, Parliament needed to be modified to prevent what they were called these, I forgot the right term, but there were certain representatives in Parliament that may have had only as few as 12 people that were represented. So they were, it will come to me, sorry. So the idea here is that there was a little bit more democratic capability in the territory of Virginia than there was in England at the time. The first assembly in this new version got together in an Anglican church in 1619. And the first setting of the legislature was one branch. The Burgesses, the council, and the governor all sat together and said, okay, this is what we're going to do. And this becomes the first representative government in the European colonies in North America. So it sets a precedent of sorts. Even though they're meeting as one, the idea of two houses of government and a executive, the governor, is now sort of set in maybe not stone, but cement that's not quite set yet, that kind of thing. They sat down, and before they had completed this session, they had new laws for the colonists, programs that were encouraging more people to come across, and how do we make this colony, how this territory grow. At this point in time, by this point in time, they probably realized that tobacco was a good plant and that there was going to be genuine interest in increasing the production of tobacco. But we need more people. We don't have enough women here to have normal reproduction, bring us the kind of population growth we want. And the more people we have, the more we're able to expand what the control is, heading from the coast inland as much as possible. So you have this interesting event that takes place over a period of days from July 30th, 1619, which again sort of sets a precedent on how governments can be created from scratch in new environments. We have one version in Plymouth where they get together and write their charter. They have sort of elect their own governors. And then you have this other selection, which is still much more king-oriented because the king is semi in control of what the colony or the company in England does. Once again, it's time for a new charter. You get to 1624 and the company, Virginia Company's charter is revoked. And now the colony, the crown takes over. It gets to a point where the probabilities and possibilities for growth in Virginia become more and more interesting to the government back in England. So they decide, let's take over. The people in the Virginia Company got their money back, and now it's time to implement a new kind of governance. The council stays basically the same. The governor stays basically the same. The governor is the king's representative. The council advise, don't necessarily consent or don't have to consent. And they tended to stay as a unicameral organization. But at least for this next 19 years, it's a single house that's doing it. The House of Burgesses has sort of been left out of the picture. So over the course of this century, the government meets irregular times. Councilors exempted from certain taxes when they're working, and different times for governmental and judicial issues, more a function of the location, the availability of people, the ability to be exempted for taxes for the time they're working was certainly to their benefit. And they would have probably tried to take as much advantage of it as possible. But various sections meeting at irregular times would have to do with farming cycles, weather cycles, availability cycles. So it wasn't something that was set in stone as to when things meet. And even today, even though it's not irregular, you'll find that state senates in some states are only in position for a very short period of time, where others in major states or larger states are in session pretty much all the time, except for certain breaks. Regardless of the irregularity, there was at least one time per year when all of the councilors would meet and all of them would be together to advise the governor as much as possible. And it seems that at least sometimes they would stay for weeks at a time. In a sense, they could accumulate all of the specific issues related to their areas of the colony and bring them all together so they could, one, negotiate off each other, which ones made the most sense. Did any of them that may have been valid for Jamestown be the same for Williamsburg, or should they be different? What should the governor do in terms of formulating some specific requirements? And it would take this period of time to get things together. The Encyclopedia of Virginia says Membership on the Governor's Council was the highest civil office to which natives or residents of the colony could normally aspire. And membership on the council enabled wealthy and influential men to increase the wealth and influence of themselves and their families. This is, again, kind of interesting because it's sort of something that's in the headlines or below the headlines, and it's related to the Federal Reserve Board and to the Congress. But in those days, if you were taking a position of authority, part of what you were doing is, one, you started with some comparatively high assets compared to others, and you were going to take advantage of your position to make yourself and your family more and more wealthy. That's why the Lees of Virginia became so important in the history of Virginia. The existing records of the council didn't start until 1680. And if you go to the Library of Virginia, you can actually follow decisions from 1680 probably through 2020, if maybe even 2021 at this point, and see how decisions were made and how attitudes changed. Jumping ahead, obviously, Patrick Henry and the House of Burgesses. This is when the Burgesses were brought back together. And the couple of interesting things, at least in the painting, is the idea of, one, it didn't seem to have particularly regular seating as people were wandering all around, but it did have a balcony where women could sit. And it's hard to tell for sure, but that somehow looks as if it might be George Washington sitting in that corner. There's another important document that pops up as we're proceeding in moving in this particular presentation. And that is the Second Continental Congress in 1776 declared the Union with Great Britain to be dissolved. And this is a real major event. You go from 1680, when Virginia is writing down its documents, and I don't have the dates in here, I'm pretty sure, of when the other colonies are established. But you've got, by this time, you've got Massachusetts is established, Rhode Island is established, Connecticut, New York, Pennsylvania, Delaware, the Carolinas, Georgia, probably have left somebody out. And now they've decided that they do not want to be associated with Great Britain anymore. All of the various trials and tribulations have led to this. And what it says is we should have our ability to form foreign alliances. Sort of going back a little bit to what Jeff's question was earlier. And what it suggests that there needs to be a plan of confederation that goes into the individual states, really should be called colonies, with the idea of how do we come together. And it took a year, basically, after this information flow goes through all of the colonies. And there's this somewhat universal agreement that we should be independent from Great Britain, from England. By the time you get to 1777, the war has been going on for a couple of years. At this point, the Declaration of Independence is announced months and days after the Declaration of Union with Great Britain be dissolved. And there should be a plan of confederation, but let's put it off for a while until we can figure out what we're doing. The Declaration itself was a statement of principles. If you go back and look at it, and I don't know what quotes I have, if any, following this, but it did not create a government or even the framework of a government. What it listed was a series of beliefs and a series of objections to what was going on in Great Britain. And as I mentioned very beginning today, I'm reading this kind of interesting book on the fact that a lot of the anti-slave movement in the mid-19th century always tied the Declaration of Independence into certain aspects of the Constitution in their arguments. So even though it's not a creation of a government or the framework of a government, it's a series of statements that are important in looking at how the Constitution evolved, if you will, to what it is, what it was and what it is now. There was no discussion in the Declaration of how politics would or should be carried out. It's this litany, if you will. It does set forth the ideas of natural rights, social contract that would help the foundation of a constitutional government. It's built off the work of the 17th century philosophers out of England, France primarily, Rousseau's of the world, Diderot's of the world, Voltaire's of the world. The idea of there's a social contract between people and there's certain rights that humans as humans deserve to have. Eventually, when they got to it, the Articles of Confederation, they had the structure that would allow this new country that had declared its independence from England to operate, both during the revolution and at least initially the plan was for it to continue to after the revolution. The years around this era Declaration of Independence are sometimes called what the Continental Congress period. These meetings of people on a somewhat irregular basis, but John estimated that as many as 1/3 of the residents in the original 13 colonies were patriots. Now think about that, if you will. That means 2/3 of the residents in the original 13 colonies were not patriots. It suggests there's a huge amount of loyalists in the country. And you have very few people, comparatively, that are really involved or interested in this separation from Great Britain. So even though the Declaration of Independence has gotten this broad dispersal, has been read in pretty much every market square in every part of the 13 colonies, you don't have that many people that are ready to jump ship. Scholars, Gordon Wood is the one I used here, said how people got caught up in the revolutionary fervor. And they were excited about, this 1/3 anyway, about creating government societies, a new nation by rational choice. This idea of, in a sense, starting up, doing something from scratch was really exciting. And the 1/3 of the residents, assuming Adams was correct, were enough enthusiasm for people like John Adams to believe that this could be accomplished. And one of the most important documents of the time was Thomas Paine's writing of Common Sense. The Declaration of Independence is critically important in terms of image and perspective and an iteration of why the United States should be free and all of the purported crimes that the king and crown had set on the United States. And Thomas Paine in Common Sense puts the whole idea of revolution into plain language. It helps incite these goals of creating a new government, a new nation by rational choice. Republican government, personal liberty for the people were to cover all of the New World. Part of what was looked at is if it can work here in the United States, it should be able to work in Canada and in Mexico, even though Mexico was probably less thought of. During the course of the early part of the Revolutionary War, there were a couple of attempts made to involve or take over Canada and integrate Canada with the United States or the United Colonies into a new physical entity. I've also already mentioned the Enlightenment philosophy, and those are the ones that lead into the next level of political philosophy. The Enlightenment writers talked about the natural man, the rights of human beings to be treated as human beings. And this sort of moved into politicians in England that were the Whigs of the time. And they were the ones that were, I can't say completely anti the Tory government, the conservative government, but they were more liberal in the way they felt the peoples that were part of the empire at this point should be treated. They felt that both the uh, United States and Canada should have different capabilities. They were not opposed to the idea of having representation from the New World come into England. And a lot of the English Whig philosophy was transported to the US and was integral into the thinking of John Adams, Thomas Jefferson. Jefferson probably more from the original French, but one way or the other, they were coming to a head in the United States. And one of the things that it said, it was rooted in opposition to monarchy they saw as venal and corrupting to the permanent interests of the people. If nothing else, their interpretation of these philosophies was, we do not want to live in a monarchy. We want to live in a place that is based on representative government, based on distribution of power, even though they probably hadn't used the words yet, because the idea of checks and balances was built into it. And there were any number of Whig politicians in the parliament during the time of the revolution and the earlier days before, when things like the Tax Act and the Stamp Act were being put into place, that were opposed to these government actions, were opposed to the idea of treating people across the ocean as second-class citizens. So it wasn't as if the United States was fighting alone, even though they didn't get support in any physical way from England. But it was, in a sense, there was this meeting of minds at certain levels. And the fact that only a third of the population really got enthused is the one that, to me, stands out most pointedly at how unusual the success of the United States was at the time. Interestingly enough, in New Jersey, in the earliest days, women were allowed to vote. That got shut down fairly quickly thereafter. In some states, state senators were elected by the same voters as the larger electorate for the House. So the state senators were getting a popular vote. Judges were elected to one-year terms. It's before there came the concept of life judges. The radical Whigs were called the people out of doors, who didn't trust royal authority. They objected to any kind of secretive group as being unrepublican. The idea of royal authority is one of the things that goes on in England at the same periods of time, 1750, say, through 1850, as the Parliament became more and more, had more and more voters, more larger suffrage base. The power of the king was being whittled down more and more, till eventually, and beyond 1850, I think, the House of Lords loses its power to basically stop any legislation coming out of Commons. So the Whigs were advanced of their time in England, and the Whig attitude in the United States was in advance of its time compared to the rest of the world. Okay, as I move forward, I was sort of jumping around a little bit on this, was trying not to give you the detail on some of the other aspects of what has gone on between. But there are an indication of what the country's wants were after the revolution. And it was universally decided the only way that people were going to be protected was by giving them the vote. Individuals had to have the right to choose those that will govern them. Virginia immediately made a cut to their vote for the governor, could run for 1 year and not be reelected. The kind of thing that would be completely unthought of in today's world. Property requirements for males, reduced to taxes on their tools in some states. So instead of having physical assets or physical land, in some of the states, all you had to be able to do was pay taxes on whatever tools you use for your farm, for your blacksmith shop, whatever it may be. And even in New York State, the few free blacks that were there could vote if they owned enough property. And I do think there was a difference in what their property requirements were from a free white citizen in the same state. New Hampshire was thinking of abolishing all requirements for voting except for religion and residency. Well, that says that you have to be a certain religion to vote, and you have to be a member of the state. But each of these individual entities is starting to look at, one, we definitely need the vote. There seems to be no question about that. But who should be allowed to vote? What the requirements of voting still were dependent on what the states felt was essential. Going back to the Whigs, for example, they arose after the English Civil War, the exclusion crisis of 1679, and the Glorious Revolution of 1688. One of the things that comes after, before Blackwell, after the Plymouth colony and the Virginia colony, are the changes that go on in England. You have the execution of a king. You have the great emancipator, who wasn't emancipating anybody in England, taking control. You have another revolution. So English in England is going through all these perturbations, and the results of that sort of vibrate through time into not only the colonies that are established by then, but from those initial vibrations into a continuity leading into the 18th century. So you get this kind of interesting attitude on the part of radicals who have seen the government change a couple of times and want to see it change even more. And they felt, the radical Whigs felt, there were two kinds of threats to political freedom. And one was more general, the idea that as people got more soft or more involved with things outside of what they should be doing, that this moral decay would cause the intrusion of evil and despotic rulers. If the people themselves get too soft, is a word, or too weak, then the king will able, or a king, will be able to become more and more autocratic. The other was they were really concerned about the encroachment of executive authority on the legislature, and that the goal was that the executive, if it had the ability, would reduce the amount of influence the legislature would have. So these concepts of the radical Whigs that go 100 years before the American Revolution are sort of inculcated through osmosis, through genetics, through whatever, into this next, probably 2 generations later, of people. And that given the choice, a mixed kind of government is the best kind of government because it precludes power from any one having power over the other. In a sense, it's a prelude to checks and balances. This is the 18th century, what the American Revolution had in terms of its reverberations through. Republican Party writings were read by many, and they were convinced that the reading of these would be very watchful for any threats to their liberties. The quote says, "Radical Whig perceptions of politics attracted widespread support in America because they revived the traditional concerns of a Protestant culture that had always verged on Puritanism. That moral decay threatened free government could not come as a surprise to a people whose fathers had fled England to escape sin. The importance of virtue, frugality, industry, and calling was at the heart of their moral code. An overbearing executive and the threat of corruption through idle, useless officials' replacement had figured prominently in their explanations of their exile in America." And the word exile is kind of interesting. For the original founders of the Plymouth colony, that's apparently appropriate. But the idea is that the radical Whigs looked at the New World, the support in America, as being the proper extension of a Calvinist philosophy into a working government. And this is how the Whigs in England thought and how the revolutionaries in the United States thought. There's an author called Robert Middlecoff who wrote a book called The Glorious Cause, The American Revolution, talking about causes and effects. And notice the years on that. The American Revolution starting in 1763 and all the way to the point of approval of the Constitution. He doesn't just condense it into the war itself, but goes into the precedents that were leading into rebellious attitudes. Most of the ideas of American revolutionaries put into their political system were part of the great tradition of 18th century Commonwealth men. And yet they affected the United States, but really didn't affect England at the same time. But overall, after the United States got created and there was a president and the House of Representatives and the Senate and the Supreme Court of the United States, the bases of these and the variations of it from Britain were sort of translated into the Scandinavian countries and the Netherlands countries. So you wind up with this interesting kind of combination of ideas being transferred into a variety of other places. Whoops, didn't realize that was at an end. But that's pretty good timing. It's exactly 3 o'clock, according to my watch. Let me get rid of this. Okay, everybody's still there. That's a good sign. Any questions, comments, anything you want to say?
I'd like to ask you a question. When did it become a law that you have to be born in this country to become president?
Oh, I'd have to go check. I don't know off the top of my head. I don't know. I'd have to check.
Okay, thank you.
Anybody know? No, okay. We mark it down before I forget.
I believe it's in the Constitution. So that would,
I'm trying to remember if it's specifically there, because I
yes.
don't think it may. I'm not sure. I'd have to go look at the Executive Branch Act and see if it does say you have to be born in the United States. You may be right. I'm certainly not going to argue it. I don't know. Anything else? Okay, thank you very much. Hope to see you all next week. Have a good week. And Josie, I'll see you tomorrow.
Yes, thank you.
You're
Thank you.
welcome. All right, thanks. Bye.
Yes.
Bye.